day, and welcome to the 9th episode of the Constitution and American Life. With us, the Friends of Publius. With us, as always, is Professor Tim Moore from the Center on the Study of the Constitution, University of Wisconsin-Madison, as well as Professor Chris Kavanaugh, residing currently in Bismarck, North Dakota, but who knows where he'll be maybe next year or the year after, possibly in the Bahamas, or maybe being a scout for the Chicago Cubs in the Dominican Republic. Who knows what his dreams are these days. And also we have with us the recently very sickly Dr. James Michael Williams from the University of San Diego. Hopefully, Professor Williams, this latest bout of health challenges has convinced you that you can no longer party away the night and have those wild times, because you, sir, are no longer 25. All right, so let's start acting our age there. Well, since we last saw you, we have experienced something so weird here in the Central Valley of California. It came out of the sky and it was wet. I Googled it, and it's called rain. The entire neighborhood was in shock. We came out of our houses, looked to the skies, and asked God, what is this? And I'm just wondering, gentlemen, are you familiar with this phenomenon known as rain? Because it is quite rare here in the Central Valley. Have you guys received any of this lately? This concept of rain, or does it come in a different form where you live?
I've heard of this thing called rain. We have been in a drought for an extended period of time, but when I left school yesterday, it was 75 degrees. And when I left school today, it was 35 degrees.
Ah, okay. So you have 4 seasons where you're at.
Oh, we have 4 seasons. It's called winter, 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 and road construction.
Okay. My lovely wife, we are in major project mode. So I was painting cupboard doors all day out, and I'll be honest, it was very cold here in the Central Valley. Now I know you're going to chuckle, but it was 47 degrees, and I was pretty chilled. So we're actually moving into another season here, and I got to get my winter clothes out now. So doesn't compete with your 35, but for us here in the great Central Valley of California, that was a chilly day today, kind of stuff. Now, and it's amazing what rain can do to the entire environment, clear out the smog. We were able to see the mountains. It was just, something that is, again, so very rare. Also, since we've last seen you, we had the second no-hitter in all of baseball history was thrown in Game 4 of the World Series by the evil and corrupt Houston Astros pitching staff. Go Phillies. And finally, just around the corner from this program is Election Day, which we should call Liberation Day for those who view commercial or cable TV, because come Wednesday, November 9th, you shall be liberated from the massive weight of campaign commercials. And boy, aren't they informative. I'll tell you, I'm learning so much about our candidates from those commercials. So today, in today's program, we're going to be discussing the colonial origins of American constitutional thought, how the notion of rights evolved from the mid-17th century to the late 18th century, the influence of British common law on American political thought, and for my own edification, I also want to talk about the role of class in American history. And so we're going to kind of break up the routine tonight. We're going to start this evening's program with Professor Kavanaugh, because he's always wanted to be a leadoff hitter. And so
I have no speed on the base pass. No speed.
Just hit a home run, bud. Hit a home run and jog.
That's right. That's right. You don't have to have speed if the sucker travels 395 feet. So, Chris, and I'm trying to remember the quote. It was actually years ago, the center focused on the fact that America is founded in the absence of feudalism, which dominates European society for centuries. And so I'm wondering, what is the significance, if any, of the idea of America being born as the system of feudalism is dying a slow death in Europe? to the way that colonists view government? Does the fact that we are born essentially without any, without a feudal arrangement impact the view that we have on government in general?
Well, first of all, Kyle Schwarber is a leadoff hitter, and he does hit dingers. So we'll just leave it at that. And I think your question is a really good one, David. And I had to actually do some research on this one because I was really hoping we'd start with Tim, but thank you. And I think that I'm going to push back a little bit because I'd say that feudalism is dying somewhat. Primogeniture, the law of entails, we see those starting to fade away in colonial America, but they're not gone. The law of entails is not gone by the time the 1760s roll around. And I would also, I would, and you guys can push back on this, I would argue that, especially in the southern colonies, in the plantation systems, I think the parallels between the feudal state that we think of in Europe, the lords of the manor, are very, very similar. So I would say that some of our major founding fathers, Washington, Jefferson, Madison, George Mason, and then the list goes on, I would say they lived in what would be a feudal system. But as I was doing some research for this, I came across some stuff, and the idea is that we think of liberties was very much tied to property, right? And then going all the way back to Magna Carta of 1215, it was really a listing of liberties that was tied to property. So there's this link between owning your land and the liberties that you enjoy. And so we see this change a lot in colonial America because land ownership is so much more pervasive. You have land ownership up and down the 13 colonies. And I came across a word called allodial. Are you guys familiar with this term? No, Tim would be because he lives in anything in the 1800s. And it's the idea is that you have the right to the land, right? Let me see if I can get this right. It's the idea that is owned by someone absolutely without any feudal obligations. So if you think about land in England, the king, he owned the swans on the land, he owned the deer on the land, he owned the other things on the land. So you got to work the land. But by the time colonial America rolls around, it's this idea that you own the land and you own the things on the land. You were not beholden to anybody. So I think what you see there is this uplifting of more people than you would have in the European culture, uplifting in terms of liberties, those liberties tied to property. Is that
well? Isn't that therefore evidence? And as I said, feudalism isn't dead, but it is dying of a slow death. And so, isn't that a piece of evidence of the death of this slow death? And again, of the American difference from Europe is the amount, the plentiful abundance of land. And again, there might be vestiges of feudalism in the colonies, and we'll turn it over here to Professor Moore in a minute, but it's not a formal, political structure as it is in France, in England, especially in the 16th and early 17th century. Wouldn't you agree? It's not formal.
I would to a degree, but again, I'm going to say it's also a matter of geography, because I would argue that the feudal system, it doesn't have the stake driven through the heart until 1865.
Right. No, I would agree wholeheartedly on that. But like I said, it is the 17th century, the 18th. It is in Europe. You're seeing upheaval, and you're seeing some dynamic changes to the feudal system and the class structure and rights associated with groups rather than individual things like that. Mr. Moore, do you agree with this?
I'm sorry, Dave. One other point too to make. I think we're fortunate. When you think about primogeniture, that James Madison was James Madison Jr. Had he been number 2 in line in the Madison family, would he have inherited Montpelier? Would that have given him the station that it gave him in life to be able to pursue what he was able to pursue in terms of his interest in government and politics? So that essence of primogeniture, the eldest son inheriting that.
Yeah, go ahead, Professor Moore.
Well, Chris, two things. Chris raises a very interesting point with this alloidial theory. And I was several years ago, I was looking into this for different reasons. In the colony of Massachusetts, the governor constantly writes back to the crown to this point of like, is feudalism dead or not? So the governor always writes to the crown, and he said he accuses these colonials in Massachusetts of taking the king's woods. That these colonists are, to Chris's point, this in feudalism, you own the land and everything on it. So you still see this rattle and hum even in New England, which is much more democratic than the South. The governor still is operating with this premise that it's the king's property and everything on it belongs to him. And these these folks in Massachusetts are availing themselves to all the timber. So it's kind of, you kind of look at it as funny, like, oh, this governor's kind of whiny, but I think it's rooted in this alloidial theory that the king owns everything on it. The second point is there was a historian many years ago who wrote this article, and the thesis was there's a lot of second sons coming to the American into North America, in meaning that they were locked out of this rigid hierarchical system. And the New World was a spot for these second sons to go and make their claim. So I think your Chris's point about it's on the decline. I think that point's well taken.
Well, do you agree? I'm intrigued by his insight about Madison. I don't know if I buy into it, Chris. In the 18th century, that Madison somehow would have been, there'd been a whole, there'd be a different path. But, and again, is it your contention that it's predominantly regional? That and I might agree with you on this, that the southern colonies very much reflect traditional European society.
Very much so.
But the middle and northern colonies, because then we can look at Hamilton, a self-made man, and without any family attachments, being able to work his way into influence fairly quickly. Some might say there. So
I would suggest that the charters themselves had something to do with the regionality of this. You had a lot of proprietary and royal the further you go south, whereas these joint stocks, these charter, I think they called them charter or these commercial charters had much more of a democratizing effect. So I think the nature of the charter and we can maybe get into that later. I think maybe this may come up in a subsequent question.
For one quick clarification, Professor Moore, because you were talking about the royal charters and the structured society, and land in Massachusetts, wouldn't the royal charter kind of pretty much provide clarity of does the land belong to the crown, or were they squishy in their writing?
Yes, they were. And there's a great Don Lutz has written a fantastic book about the origins of American constitutionalism, and he makes this argument that we've gone through, there was a stage, it was a process, a progress of how people constituted themselves, loose covenantal social communitarian arrangements, and then as time went on it became much more codified and legal, and then they wind up being constitutions. But I think to your question, I think I would say there's a progress, and there's also some regionality to it in the nature of how those original charters weren't real specific in structures and powers. They became so after about 15-20 years, but originally there was a lot of vagueness.
Well, also, let me jump in real quickly. Sorry, Mike. Is that, from Magna Carta 1215, you get to the middle 1600s, and whether it be the Massachusetts Body of Liberties, West New Jersey Charter on Fundamental Laws, these are things being done in the middle 1600s. And and students will know that the period of salutary neglect, where the crown and the parliament, the kind of that period of benign neglect where they're not really paying attention. So as the colonies have their royal charters or proprietary charters, or if they're a joint stock company, depending on their origins, they're writing stuff independent of England, but based upon the common law and Magna Carta. So a lot of property rights tied into those, which will go into other liberties, as I mentioned before.
Well, to what extent is what is happening in the middle 17th century in the American colonies a reflection of what's happening, especially back in England, but in other European states? I mean, England's in the midst of civil war, in the mid, 17th century there. And I wonder to what degree the ideas that are being fought over in Europe are crossing the Atlantic and shaping and framing some of the viewpoints amongst the American colonists. I just wonder there. I did want to ask you, Professor Kavanaugh, do you think it's important for students to understand the context of the feudal system in Europe?
I think, it is, because that's part of our heritage. I think because, you want to understand how things have evolved over time, or from whence things have come. I think, as we're all historians, even Mike is a historian to a degree, even though we give him grief about being a political scientist. That, I think we are the belief that it's important for us to understand this, because if you know the roots, and you can talk about how it has changed. And because I would argue, back to some of the things I just mentioned, the stuff being written in the middle 1600s, they're writing this based upon their heritage as Englishmen, because this is what they know, right? This is what they know, whether they're being influenced by the English Civil War or not. They know the idea of protecting property rights, and so they're codifying this in their local charters and their local laws.
So, Professor Moore, I have no idea. I think this term is more of a presentist term there, but this notion of rights consciousness, is that this notion of individual rights rather than rights associated with a group, is that a part of colonial thinking from the very beginning of the colonial experience, or is it something that evolves over time to kind of flower in the later part of the 18th century?
No, initially I don't think rights consciousness is an inappropriate term to apply backwards. I think rights are very much in the forefront of their thinking from the get-go. And I think I would suggest there's basically two reasons why these English folks coming over are very concerned about rights and I maybe have mentioned this in previous episodes, but all of these folks are very keenly aware of what went on in Ireland in the early 1600s. I'm talking like 08 or 9, when the English try to basically subdue Ireland. And they create, I think it was called the Plantation of Ulster Project, where basically it was like, we're going to run roughshod over all you folks. We're going to send in the Scotch Presbyterians, and basically we're going to run over you and subdue you. And there was a great book written years ago by the author's named McElwain, and he makes this argument that these British colonials in North America are keenly aware of what happens when England defines you as outside the realm or a defeated people. So you'll notice that a lot of these right off the boat covenants, or sometimes they use the words covenants and compacts and charters almost interchangeably, but they always say stuff like, the mere fact that we've hopped on a boat and come over here does not diminish any of our rights as Englishmen. Every single one, that statement is in there. We possess all of the rights that anybody, we're in the realm. We are not a defeated people. We are British, and we possess all the rights of Englishmen. So I think rights consciousness is very much in their frontal lobes, because they know what's happened in Ireland, what happens when you're defined as outside the realm or a defeated people. The other thing I think that really forces them to put rights in the front of their brains is they know that in the French settlers and Spanish settlers do not enjoy equal, let's say, equal rights if they're not on the mother turf. So they're doing a little comparative work here in knowing that the French and the Spanish settlers don't enjoy the same status. So I think Ireland is a factor, and I think when they look at other settlers from other kingdoms, rights becomes very, very important. And very quickly they start to very quickly they start to specify. Massachusetts Body of Liberties is a fantastic. I mean, there's all kinds of rights all in that. So rights consciousness is there from the beginning. That would be what I would say. Yes.
Well, I'm wondering, and this is kind of to all of you. So you're saying that, is it correct to say that this rights consciousness predates the Enlightenment? You know, because I've always understood
sure.
that the notion of individual rights.
Well, and where they came, it's an origin difference too. By the time you get to late Enlightenment, there's this notion that there's a transcendency, there's a transcendent where you gain your rights. It might be a god or some kind of transcendent, or rights pre-exist government. That's Enlightenment. But the rights consciousness is long before that. I mean, there's an argument goes back to, there's rights consciousness back in the in ancient Greece and Roman times. But I would say the rights of Englishmen it doesn't rely on Enlightenment notions of how rights works. Excuse me.
I think that explains, throwing in the Enlightenment with what Tim said, because, all the way back to Magna Carta, as I mentioned earlier, the idea is really about liberties. Of course, it's very limited. We know to the barons, it's very limited. I'm with you. So it is a very limited thing, but it's the idea of the rights of Englishmen, as we know. And so you're tying this, and then you fast forward and through the colonial period, through multiple colonial documents, expressing those liberties as Englishmen, right? Then you get to the Enlightenment period, and then, the French and Indian Wars over, we're starting to digest some of this Enlightenment writing. And it's like, okay, from where do these rights come? And if what is the role of government in securing these rights? And most of the students who are listening to this will understand, will have read the Declaration of Independence already, and Jefferson plagiarizing a little John Locke. So that idea that there are rights that are perhaps transcend our Englishness, so to speak. So I think you see that metamorphosis from the rights of Englishmen, say in the mid 1600s in the colonial America, to the 1760s, 100 years later.
Professor Williams, we tend to view the Southern Hemisphere of the world, through very different eyeglasses when it comes to political thought. I'm just curious, based upon, especially your focus on Africa, is there kind of a concurrent thing going on in that area of the world? This notion of a rights consciousness of individuals, or again, is it more traditional culture of rights associated with tribe and family and things like that? I'm just wondering. Can't hear you, Mike.
You're muted, Mike.
You're muted.
Sorry, I was trying not to let you hear me cough. Okay. That's a good question. It's really, really hard to generalize across all the different thousands of different political entities. Just as we were kind of describing how feudalism in England is different than feudalism in France and feudalism in Russia, Africa has tens of thousands of different types of political communities. What I would say, though, is what's in common is, like feudalism, is that powers exercised, there's an economic base of power, and feudalism is the base of that power is the land. And the having access to those means of production. So I wouldn't call them rights. I would say your privileges within that system are going to manifest themselves as how many privileges do you have with the land? Like, are you working the land completely for someone else, or are you working the land a little bit for yourself as well? And we see in African kingdoms and African chieftaincies, we see that principle at play, where the chief of a local community would own all the land. If you were of the warrior class, he would give you access to the land of which you could keep some of that agriculture for your own homestead. The rest would go back to the chief. Whereas if you were from a different class in that society, everything you would produce would go to the king. So I see this as kind of, I mean, I'm basically kind of like, you know, doing a little bit of Marxism right here, right? In terms of just generally thinking about modernization and how economic bases relate to political power superstructures. So with feudalism, you don't see liberal democracy. You don't see participatory democracy. You see a centralized ruler of which people pay homage to. In the case of what we were just talking about, it's super interesting because even within those systems, there are privileges. And then people who could be in that system and not be super high up may say, well, look, we're going across the Atlantic, but we're still in this system, because to be outside of that system meant you got nothing, or to be under the reign of the French or the Spanish. So there is that relationship. And once people get access to their own property and their own more access to the means of production, as Marx would say, you see a transition not only in the economy, like the North becomes much more industrialized than the South. And therefore, you know, Marx and other modernization theorists would say that's the driving force for liberal democracy, because you have this middle class that now says, you know, like, look, why are you taxing us and making us go to war when we don't have a say? So I went from Africa a long ways around there, but I really do, as Tim was and Chris were talking about it, it was just in my mind that I think it's super interesting for the students to think about how there is this comparative dynamic, how we see in the North, I think, feudal, like Tim said, the governors are writing back saying, are we still feudal? Like, I mean, the elites within the system want it to be feudal, but I think that had something to do with the economics. I think in the North, the economics system did not lend itself to reinvigorating the feudal system. And I think in the South with plantations, I think it does. And I think that means dramatic differences in the North and the South about how they develop economically and politically.
So, Professor Williams, another area of which, you know, I guess in some ways we reject elements of the English structure and values and systems is the common law tradition in England. And I'm wondering, did that tradition, in your opinion, the common law tradition, die with the American Revolution? Or even post-revolutionary, post-constitutional period, is there an element of common law in America's constitutional system?
Yeah. I see Tim smiling, and I'm hoping he's smiling because he's thinking, of course it didn't die, because if he has something else to say, it's going to be interesting in a few minutes here. I would say no, it didn't die. I mean, the way that one of the first things that you are taught in law school is that we are a common law system and that we borrow that from the British. Now, I'm not enough of an expert to talk about maybe the nuances of this, but one way for students to think about this is there's usually a dichotomy between a common law system and a civil law system. And under civil law system, the major source of law are statutes. And they're written statutes, and those statutes are meant to try to envision all the different circumstances of which this law could be applied and all the facts. And then if there's a conflict, it doesn't give the judges as much latitude to rule on the law, right? Because the statute would say, under this circumstance, do this, right? Our system at the beginning, for sure, was judge-made. I mean, common law is case law. It's judge-made law. It's very, very local, means for the students to understand, much of the foundations of our contract law, property law, injury law. That's all kind of coming out of a local dispute in a local hamlet in Massachusetts, and the local judge ruling at one point, under these circumstances, I'm going to apply the law in this way, and I'm going to resolve it in this way. And then 2 years later, when a similar conflict comes up, another judge from that area says, you know what? My fellow judge 2 years ago had the same fact pattern, had the same kind of law. Stare decisis, right? It's precedent. I'm going to continue that. So we now have developed a system where we have obviously statutory law, we have constitutional law for sure, but that legacy of case law, of judge-made law, of judges having a lot of authority in local communities to apply the law and to interpret the facts, I would say it doesn't die at all with the
revolution. I need a point of clarification. So you're saying common law is judge-made law. So legislative acts are not part of the common law tradition?
Well, in England, they are. I mean, it's all a part of this big chunk of stuff called law in England.
Okay. So how's that? So I'm going back to my high school studies here, and it seemed like there was a big deal that we reject the British unwritten constitution, common law tradition, and have written constitutions both at the national and state level as a way to codify things, maybe more in the civil law tradition. Was my high school government teacher wrong? And this
Yes.
goes way back into the 70s, so maybe they were. So,
David, I would say, I mean, that's a fair point.
that'd be the 1970s, Tim, just so. I'm sorry, Mike, go ahead.
No, that was good. I mean, I think it's a difference in terms of what level you're at in some ways. I mean, I think simultaneously, and Kim and Chris, correct me on this, simultaneously, colonists are setting up their colonies, and they're maybe writing, I don't know, colony-wide statutes, what we might call constitutions or something. But they're also relying upon judges and magistrates in local communities to solve disputes. I see it kind of happening together, and I think they inform one another. I think that, I know that sometimes what states will do in the United States is after 30 years of certain precedents with common law, that becomes state law because it kind of becomes cultural, right? It's just the way that we do things in our political community, which I think then, talk about a seed of federalism planted at the very, very beginning. I think maybe common law is one of those seeds that really, really privileges sort of decentralization of decision-making. But I don't know, Tim and Chris, if you'd agree with that.
Well, two things. I think I would agree, and I think David, I think your history teacher, government teacher, was probably much like mine, and part of that is the American exceptionalism idea that we have created a system that's different, right? But it's really not. It is still based to a degree on common law, but we don't want to say that because we have a written constitution as opposed to an unwritten constitution. And the other thing, listening to Mike talking about things, I keep thinking of, Tim and talking about the anti-federalist viewpoint on judicial review. And it's not a question of one Supreme Court, it's a question of taking away what we want at the local level, because we know our local judges are going to be following that common law established in our colony/state. So when this Constitution comes along and establishes this one Supreme Court, we're worried about perhaps a usurpation of our local interpretation or our local, the lawmaking process that our local courts have served in our colony/state.
There's another, I couldn't help but think that there's another angle to this common law. Is it still around? When did it switch? And it's always been interesting to me that a lot of in the 1760s, a lot of petitions that went across the pond to England were based in common law logic. In other words, we're British colonials and we think you violated some principle in British common law as it relates to us. So many of their appeals were common law appeals. There's a switch that takes place somewhere, maybe in the early 70s, where the appeal is no longer to common law, and the appeal now is to more of a natural law type logic. And at that point, there's a natural law logic to declaring independence. Whereas in the 1760s, I think the appeal is for restoring traditional British liberty. So I think there's the common law, and this may get to your high school teacher question. Maybe as Americans, we like to see ourselves as this switch to a natural law logic in the trajectory of how the revolution comes around. The evolution from British common law, which is obviously inferior, to a better American approach to higher law or natural law as the basis of a revolution. So I think, but then to Mike's point, I think it reasserts itself when judges have to start making decisions. And that those precedents become a part of what I would call American common law.
1760s to 1770s, insert Enlightenment thinking here.
Well, I would say they just weren't being. I see the switch to Enlightenment logic as a. I'm not as keen in putting more nobility to it.
Well, I wasn't saying it was a noble thing. It was like, okay. The whole idea, like their appeals were based upon their rights as British citizens in the 1760s. You know, James Otis,
right.
Subsistence cases, right?
Well, and even Dickinson, Letters from a Farmer in Pennsylvania.
Yeah, absolutely. But then all of a sudden we roll into the 1770s and we start thinking about these higher notions, right? This concept of higher law that's maybe being violated.
But the irony, you know this, Chris, in the Declaration, the list of grievances are all common law gripes.
It's all common law.
They're all common law gripes.
Well, but
so I just find that fascinating.
Well, the thing is, we don't focus on those. We focus on the first few wonderful paragraphs. We don't go to those lists of bitches that they had. Oh, complaints. Sorry. Sorry, kids. Sorry, teachers.
Well, I find it interesting because the question that the students are asked and the teachers have to grapple with as well is that the common law tradition in the colonies, they imply that there are winners and losers in this system. Can you guys help me make sense of that? Who benefited under this system of English common law, and obviously, therefore, there were those who did not. Can you help me make sense of that?
Absolutely not.
Well, Arthur, I mean, Mike's the one that brought in Marx earlier. So aren't there winners and losers in every system?
Well, that's a good question, and one maybe I'd like to address here later on.
We should ask our political scientists here about the winners and losers.
I don't have an answer to that. I mean, that's a good question. I guess I would say that the tricky part about, a judge who's ruling a decision and that decision is going to become the rule of the law in that community, common law says he's basing it on, or she's basing it on, what are the norms and rules of this community that he or she believes should be applied. And there's a lot of power in that origin story. I mean, once a judge kind of makes that determination that in this community, this is what we are going to do in this situation, right? It's hard under this tradition for a judge to ignore precedent. Now, we know judges do ignore precedent, but it sets into motion something that you could see it as small c conservative, like making change is going to be hard. The way you would have to change that would be for a higher body, a state legislature, to say, look, we know there's been 40 years of common law tradition of X. We no longer think that really reflects our community. It reflects one's part of our community. So therefore, we are passing this piece of legislation that basically, judges, you can't say that anymore. Now you have to follow this legislation. So there's that push and pull there. But then it's like you have to ask yourself, okay, who gets access to these legislatures? It's kind of to Chris's point. It's it's going to be this vicious cycle, right, of power and privilege that's going to be hard to sort of uproot.
Well, Mike's point about access into the legislature, I mean, is a great point, because and I go back to the charters. The royal, the access to the legislature is pretty narrow, you know, for commoners to have access into those royal charter legislatures. So I think the nature of the charters would factor into answering your question, David, about who the winners and losers are in British common law. Because I would say in large part it's because of what the original charters and subsequent evolution of the constitutions within those certain charters would evolve to become.
Yeah.
So, Professor Kavanaugh, constitutional government, I guess in its simplest form, implies the existence of a higher law. What was considered the higher law during the American colonial period? And as a kind of a secondary part to that, is there the same focus on rule of law during the early middle colonial period as there is during the post-revolutionary period?
Yes, I think yeah. I mean, to your second part first, I think there was still the same emphasis on the idea of rule of law. I don't know that in the early colonial period, you're going to find a lot of that specific type of language being used, but there was idea. I mean, let's face it, as the students are well aware of, you have the Mayflower Compact, right? So before we even get off the boat, we're going to agree to this set of rules, right? We're going to create a compact, this compact theory of government, and we're going to agree to it. And in essence, that does establish what we would know as, to a degree, a higher law. We alluded to this earlier, and this actually addresses the concept of common law, going all the way back to Magna Carta. I know just the barons, 1215. I got it. I see you, David. But it's this that plants the seed that we know will eventually sprout, and it's tied a little bit back to the concept of property. And this access to property will grant liberties, or as Mike, I think, used the term, privileges. And as Tim alluded to in the language, we are part of the realm, right? We are not part of the domain. We are part of the realm. As being part of the realm, we have the rights of Englishmen. And that is linked to the concept of a common law and precedent established by Parliament as well as judges. And that works its way over here too, because you see this happening in the colonial period. And I think that speaks to what we just talked about, and that shift from claiming the rights of an Englishman, right? And what Tim had just talked about in the 1760s and some of the early petitions to the crown, you know, hey, we're you guys, we're with you guys, we're parts of you. And as being loyal subjects, please make sure you're protecting these liberties that we have. We get into the 1770s, and it's like, well, you know, there could be some other ways of thinking about this. That's when I talk about the Enlightenment thinking coming in.
It's interesting. I would make the argument that there's a higher law principle in even the pre-Constitution documents in the colonial world. They get off the boat, and these first of all, these communal agreements. Maybe I'm quibbling here, but I don't know whether I heard you right, Chris, when you said like Mayflower Compact was sort of a constitution. I guess I would look at a lot of these very early documents as we're creating a group identity. The rule books are going to come later. Mm-hmm. But even when they hop off the boat and they make these communal agreements, they do make statements about higher law, our dread sovereign. They make that word dread sovereign, ultimate sovereign, our king, is in all those very early documents. So I'm suggesting that could be language perceived as there is a higher law, and it's rooted in a monarchy. Now, at the same time, these dissenting groups coming over, they're going to tap into biblical law as higher law. Sometimes they'll combine common law and biblical law. So I think there's a mixture of how they're defining higher law, but it is interesting that all those original statements, like right off the boat statements, they're making statements about the divine right. is what the language infers. Now, whether they want to live that way truly is a different
Well,
discussion.
I think you're right, Tim, and the idea of the tip of the hat, and you see that, and you know this better than any of us here, but the stuff that I've read that you've given to me to read, there's so many things for so long. The colonists are always tipping the hat to the crown, right? They're always getting their nose up the crown's rear end, so to speak. But I think about the word Constitution itself. And I think the Mayflower Compact constitutes a set of rules for people to follow. When you think about the language,
Well,
Tim's smirking. I can see it.
No,
Yeah.
well, we can respectfully disagree on that. I don't see much constitutional language. I see identity and coveting.
Well, that's exactly my point. The idea of the word constitution, it constitutes a people, right? So
Okay.
So whether it be the Mayflower Compact or some of the earliest colonial documents, we are, as you said, a sense of identity. This is constituting us in a way.
So just to make clear that, from a contractual point of view, you've got these colonial charters. All right. So the charter is a contract. Is the charter the higher law? And does the charter make it very clear that in the last analysis, it's subservient to parliamentary or to British common law and the whole arrangement in England? Or is it a separate, whether you want to call it constitution or covenant, I'm wondering about that relationship between the charters and British common law and again, king and parliament.
Well, it's interesting. Like take Connecticut, for example. Well, first of all, originally charters are for like towns. These charters are not for large geographic spaces. Charters are for individual towns. So when you look at Connecticut, for example, you have it's like a handful of these towns in Connecticut, and then they create this thing called the fundamental orders. Well, there were charters that existed at a town level before the fundamental orders of Connecticut in, I don't know, 1640 or whatever it was, 41. The fundamental orders, in a sense, this is British federalism. What happens here is you have town charters and they're on their own, but then they create a larger structure like fundamental orders of Connecticut. And so, there's this, what evolves is the fundamental order, there's like a larger colonial government, and then there's these town things that have their kind of local sovereignties. So the evolution from individual town charters expanding outward to larger geographic spaces. I mean, Massachusetts goes through this. You have Massachusetts Bay, and then you have Plymouth Bay. You have all of these little towns, and then they start to consolidate into larger entities. And it becomes kind of a quasi-federalism system because charters are at a very local town level to start with.
Well, doesn't that become the problem in the 1760s, 1770s? I.e., again, aren't the colonials arguing that England's violating the higher law here?
Well, that's if you take the argument seriously. But yes, David. Yes.
I gotta get those textbooks that are ripping out pages. Yeah, kind of thing.
It's like Dead Poets Society.
We should create a history book. Don't take this seriously.
Federalist men dead. Appeals the higher law.
So I got to push back. Why should we not take that seriously?
Well, first of all, why am I in the hot seat? Why does this happen?
Because you just said we should take some of that stuff seriously.
All right, fair enough. When I look at the 1760s, I think they're operating as good British folks. And I see the move to natural law logic as a move of desperation. We're not getting anywhere. appealing through the common law and Magna Carta and all these traditional things that appear in British common law. Parliament's not paying attention to us. And so the move to a natural law logic, I see as a kind of not last ditch effort, but a switch. And no self-respecting British attorney or barrister or parliamentarian would look at this and say, "Are you kidding me? What are you talking? Natural law? I thought we ran Locke out of the country 80 years ago. What are you talking about?" So this, to me, I just look at it as a historical argument that's rooted in history and common law, and then the ground rules changed, and the logic of natural law I see as a desperation move. Now that's a highly debatable view, but that's kind of how I see it.
Well,
Probably because I'm more of a historian than a political scientist, frankly, but that could be a part of it.
So let's get to the colonial, governments.
Oh, you're not going to let Mike and Chris push back on all that?
I paused.
Okay.
I don't know. I mean, you're slamming me as a political scientists. We recognize that sometimes people say things because they're trying to get power. It's not always like earnest or sincere that they even believe it. So I mean, I don't know the history well enough, but I don't see. I mean, I think it's convincing. Like if you're making the same argument over and over again and no one's listening, and correct me if I'm wrong, Tim and Chris, but the appeal to natural law for a group of people that is slowly kind of coming to the determination that maybe they're just different from their British brethren. It has a popular appeal, maybe because it is new, right? Yeah. And that plays into the power play for me. So I think it makes sense.
Well, and you see that. I mean, this is not a program about the Declaration of Independence, but as we've on other programs, we've seen those ideas up and down the colonies, right? That switch and that appeal to an Enlightenment thinking. That argument. I just think that's a fascinating viewpoint that I really had not considered before. Yeah, what Tim had just talked about.
Well,
I would caution students, if you be very wary of making that argument in front of a panel of judges. Make sure you got a historian on the panel before you make that argument.
Let's tell you why appeals to higher law were out of desperation.
I like it. And it's got to be a certain kind of historian, as you know, there at the University of Wisconsin, Madison, professor.
Yes.
There.
Yes.
So. I am wondering about colonial governments. Again, in the simplistic form, it's the common explanation is that there's a consistency across all colonies. The structure of government is pretty consistent in their fundamental principles. Is that accurate, or is there an outlier, or are there some differences from colony to colony? And I know part of it's going to do with the arrangement of the charter itself, but if you could give us some time on that.
Well, all the governors are royally appointed. I mean, ultimately, the king's signature is in if it's a joint stock or if it's proprietary or if it's royal, ultimately, the king can revoke charters, no matter what kind of charter it is. Now, whether or not that happens or not is a different question, but ultimately, legally, the crown owns these places, even though they're joint stocks or whatever. But the governors are all royally appointed. Access to the upper house is usually an aristocratic. Sometimes that comes through connections within the colony, or sometimes outside the colony. Proprietors are interesting. So yeah, there's separations of branches. There's that. There's usually upper houses and lower houses. There's voting there's property requirements for voting, sometimes lower property requirements for the lower house. In kind of ascending scale, more property gets you upper house votes, or if there is a democratic input into the upper house. And then large property, so there's a graduated property dynamic to how voting works. So yeah, I think this separation is there. The governors are royally appointed. There's always a tension between lower house and upper houses. That's always a dynamic in in the colony. I mean, a great case study is Bacon. It shows so much about how the Virginia government works in the Virginia colony, the resentments toward the royally appointed governor, the upcountry yeoman farmers in the lower house. So Bacon's rebellion would be a good case study, I think, for colonial politics, a microcosm of British colonial politics. So there's great similarities from place to place to your question directly, David.
Oh, so I want to finish here kind of on a tangential issue. And I came across, it's a short little article from an obscure organization. And I recently read this article, and it argued that those nations formed out of the common law tradition tended to establish governments that were more likely to promote property rights than expansive democratic institutions. That if they had to choose between more democracy or more property rights, they go with property rights, they go with capital formation, and elements like that. And the argument seems to go that they do so because the wealthy money classes are the ones in their structured government that have the reins of power. And so they're going to govern from self-interest. And it made me think about the notion of, we talked a few episodes ago about republics and democratic republics. And it seems to me that throughout the last 200-300 years of the history of the West, that all democratic republics, in my view, tend to perpetuate an informal class structure in which political power is held in the hands of those with the property, the moneyed classes, and that there really is no economic justice in democratic republics. Professor Williams, what do you think about my view here? That one of the great failings of democratic republics is it just has never dealt with the class struggle from a Marx point of view and created a system of economic justice, mainly because government is the representatives in government all come from those moneyed classes.
Yeah, I mean, okay, so that argument is Marx's argument about liberal democracy. I mean, liberal democracies are the superstructure to keep the people happy while the base of capitalism continues to work. And if you happen to, if you're in a system and there's surplus labor and your labor isn't needed, then you end up experiencing homelessness and you just kind of fall through the cracks. So I think there's a lot of evidence for that. Yes, I guess it's hard for me. And we talked about this earlier before we went to record this. I'm not sure about the origin story with common law. Like I'm not aware of that argument.
Well, the way I understood it, like I said, I tried reading this a couple times because it was, it was above my grade level in a lot of ways. But the idea is that the magistrates, the court-made law, the judge-made law, who do these people, they are part of the moneyed classes. And of course, when they make this law, they're going to have their own self-interest. Now, if it's English and it's parliamentary, well, who's sitting in parliament? Yeah. And the same can be said, because to me, Mike, it's the 21st century. We're still having the same arguments that we were having in the 1870s, 1880s about economic justice and democratic government there. And I think part of the American narrative, the exceptional story, is that capitalism and democracy go hand in hand. All right, you can't have a democratic system without a capitalist economy. And my view of history, and maybe this is surprising to myself that suddenly I've adopted a Marxist view here, but we're still, to me, living in a period in which justice, whether civil, criminal, or just pure economic justice, cannot be obtained because the reins of power are controlled by those in the property money classes or corporate America. Today, I've been reading this book called Dope Sick, and I look at Purdue Pharma and one of the wealthiest families in America, the Sackler family, and they're personally responsible for the death of hundreds of thousands of people.
Yeah.
Yet they will not serve one single day in jail for their actions because the way that the law is written, all right, and corporate law and things like that, they're able to separate their individual responsibility from the actions of the corporation. And we can look at all over the place how that happens. I'm sorry, kind of a rant there, but does that help? That seems to be the origins of it.
Okay, so I guess I'll just say this pretty quickly because I want to hear what Chris and Tim have to say on this. I think what you're describing happens all over the world, whether there's a common law tradition or a civil law tradition. So that I think this just has to do with some other factors that I'm happy to go into, but I think it's not based on that. But what you're describing is real for sure. The only other piece of information I can bring to this for the students, because this is a highly, very not complete answer, is that the little research I've seen on, okay, if you were a British colonial power or whether you were under French or Spanish colonial rule, the literature is pretty clear, at least in Africa, that you were more likely today to be more democratic if you were a British colony than you were a French colony. Now, that's not really what you're getting at. You're getting at not whether you can put on a map whether you're democratic or not. You're talking about how power actually operates and wealth distribution. And again, I think that's something that doesn't have to do with common law or civil law, has to do with other things. But I think there is that distinction I found in literature about that. And I don't know if that's rooted to common law or not. So I'm going to stop there.
Chris or Tim?
Well, your point is well taken. There's two great pieces. I'm going to reference the Federalist, anti-Federalist debates. There are a couple of really fantastic anti-Federalist critiques of the Constitution. In fact, Sentinel 3, I think he uses the phrase, this document is a system, the Constitution, that perpetuates the wealth and power of the well-born few. Federal Farmer does a similar thing in his essays, critiquing the Constitution on the basis of class. Now, I think it's for a lot of people that's like, whoa, wait a minute, these are Americans making these economic observations about the Constitution. Now, of course, anti-federalists are going to run the system out and see down the road we're going to have this perpetuation of wealth and privilege. But my point is that was there at the Federalist, anti-Federalist debates, the issue that you're raising, that this Constitution. Now, at the time, I don't know, it was perceived that it would be common law. The Constitution would be the same as common law, but they were running it out down the road of history and saying that this is going to perpetuate a class system. And we'll send links to these specific pieces of Federal Farm, because Federal Farmer is a really long piece, and we'll send a link to Sentinel 3 and his Federal Farmer essay that I think is fantastic on the issue of class.
I just have three things. First of all, I didn't know, when did Charles Beard become our moderator?
I've always been a fan, even though I remember one of my teams got just slapped down by a judge because they were making a Beard argument. And he said, nobody in the academy accepts Beard any longer. This was in the 1980s, early on in the program.
Well, that's partially true.
Of course, the students all look at me like, hey, thanks, dude, for giving us some guy.
For the students and teachers watching, Charles Beard in the 20s, talking about the Constitution was merely an economic document, and it was drawn up based upon preserving the economy of those that had the money. The other thing I was thinking of is the golden rule, and you guys know the golden rule: he who has the gold makes the rules.
Oh, I was thinking about another one, but yeah. Okay.
Well, and the third thing I was thinking about was Federalist 10, and you guys have heard me talk about this before. You know, students, you guys in for AP Gov, you got to read Fed 10. It's all about the factions and that. But my contention is the key part, and I will read it to you out of my duct tape together American legacy. The diversity in the faculties of men from which the rights of property originate is not less an inseparable obstacle to a uniformity of interests. The protection of these faculties is the first subject of government. From the protection of different and unequal faculties of acquiring property, the possession of different degrees and kinds of property immediately results. And from the influence of these on the sentiments and views of the respective proprietors ensues a division of the society into different interests and parties. We might call those classes. That's Madison talking about the first object of government is to protect the interests of people for acquiring property, knowing that full well different people will have different property. And going back to my point of him being son number one, he gets all the property.
Well, and as I've said a few times, Madison, they're all speculating, of course, in the Federalist Papers, trying to make an argument in hope for ratification, and they're all keeping their fingers crossed. As Benjamin Franklin said, a republic, if you can keep it, kind of stuff. I think Madison ends up being wrong in that sense, that the design of our Constitution was somehow going to stop the concentration of wealth and create a mighty faction.
No, I think my point in that, David, was that he was arguing for the fact the role of government is to protect our ability to acquire property, right? And that we know that different men are going to have different faculties, different ways of acquiring that property. So his argument is a very capitalist argument. It's a very
it's capitalist, but it seems to me the end result that he's hoping for is a more equal distribution through universal property rights.
No.
You're going to argue no. He's just perpetuating the same old system.
I got mine. I got mine. You get yours.
Well, there's a interesting note to bring us to our last and final part of our program and our tradition. If I could have each of our experts kind of make some recommendations, insights about this question to students and teachers. So, Professor Williams, what would you suggest to students and teachers?
I want to highlight, actually, David, what you called your rant, which I want to. I don't know. I just want to highlight. I think it's important to be passionate about these things and to see how this question about something that seems so long ago, there are seeds of it that we can still apply to today. So what I'm reflecting on at the end of this conversation is that we started this conversation with a question that the premise was there wasn't feudalism in the United States, and therefore there was a certain type of political development. Of course, I'm not arguing we're a feudal system today at all. But feudalism was based on the notion of no social mobility. If you were born into a certain class, you died in that class. And the unfortunate reality, students, for us today is that for the first time in our history, all of you are less likely to experience social mobility than any previous generation. So something is happening in the Democratic Republic. That this promise that was made, this desperate plea to higher law, whatever we tell ourselves about ourselves and tell ourselves that what we're not, like, we're better than them because we were never feudal. I would just ask you to really think about the history and examine the history and think about these arguments and just ask yourself about the communities you live in and determine how easy it is for people to improve their social mobility and whether that rings true.
Professor Moore?
Yeah, I would make a recommendation that on your panel, one person specialize in Virginia, since that's the question, and another colony. And the next person focuses on Pennsylvania and maybe another colony. And then, so however many people you have on your panel, have them really read up on two colonies, because the first bullet is about what constitutional principles from it's an invitation to know stuff about other colonies is what I'm seeing in that first bullet. So I'd have specialties within your panel to really nail down the ins and outs of how no, I would include Pennsylvania. I would put that there because it's really fascinating. Penn really has an axe to grind because he got really shafted in a trial back in England. So there's a lot of due process in Pennsylvania because he probably didn't get much. He didn't get much in his trial in England. So I specialize in specific colonies, and to that end, my other recommendation is a document book that Don Lutz put together again. All kinds of colonial charters and compacts and constitutions, and more than you'd ever want to know. So the Don Lutz book is really helpful for that.
That must be your mantra on a daily at work. This is more than I ever want to know.
Well, there you see those, those volumes right there, more than you'd ever want to know.
Professor Kavanaugh.
Well, I liked what both of my colleagues have said, and for the students, in this is such a deep, rich historical question. You're going to be lucky if you have Tim Moore as your judge, and you're going to be unlucky if you have Tim Moore as a judge.
Well, yeah, I don't know.
No, I'm sincere, because the thing is, because this is such a focused kind of question. We know, and I'm not trying to, I know the judges in this program are volunteering their time, and this program would not work without the judges volunteering their time. And we have all served as judges, and we know how important that is. But the majority of the judges will not know the history of this to a great degree. So students, I'm going to, in many of these cases, for many of these questions, actually in many of the units, but for this one especially, for you guys that really dive down deep into this, you're going to be way above most of the judges you have in terms of your history. So stick to your arguments, stick to your guns. I love what Mike had to say about, there was a degree, Mike, I heard a degree of presentism in what you're talking about, which is not a bad thing. And Tim's point of specializing, and know your own state as well, right? Yeah. Know your own state, no matter from where you come. Know your own state and its constitution and the origins from territory to statehood, and how that worked in your state for folks as well. That's what I would say.
Well, I didn't know if I would enjoy this session and its subject. Is I think a few of us on this panel thought this would become the just ask Tim to talk, and the rest of us will go have a cocktail or something. But it ended up being a great discussion. In fact, my highlight, and of course this says much more about me than anything else, but Professor Moore said dread sovereign. And immediately in my mind, I thought about the Dread Pirate Roberts and a great story, Princess Bride, marriage, and you killed my father, prepare to die. And so if you've never seen The Princess Bride, you may want to do so there. In our next session, we're going to be looking at the 14th Amendment, its impact on federalism, the Equal Protection Clause, and how that applies. Obviously very relevant today, given the court just had a discussion on affirmative action. So we look forward to that discussion next session. Until then, peace, love, yogurt tacos. Bye-bye. Bye-bye.